Question 1. A New Jersey notary's official stamp must include all of the following information except A. The notary's name as it appears on the commission. B. The words, Notary Public, State of New Jersey. C. The notary's commission expiration date. D. The notary's commission identification number. Answer: D. The notary's commission identification number. The official stamp must legibly include the notary's name, the title, Notary Public, State of New Jersey, and the commission expiration date. New Jersey law does not require the commission ID number to be part of the stamp, which is a common point of confusion for new notaries. While the ID number is a crucial part of the commission itself, it is not a required element on the physical stamping device. Remember this by thinking of the stamp as public-facing information. Name, title, and expiration are what the public needs to verify the act, not an internal ID number. Question 2. When a signer, due to a physical disability, executes a document by making a mark, the notary must ensure the act is witnessed by A. The notary alone. B. One credible witness who knows the signer. C. Two witnesses, in addition to the notary. D. A licensed medical professional. Answer: C. Two witnesses, in addition to the notary. New Jersey law specifies a clear procedure for a signature by mark to ensure the validity of the signature and protect vulnerable signers. The person making the mark must do so in the presence of two witnesses, who then sign their own names on the document near the mark. The notary's role is to notarize the signature of the principal, the person making the mark, and sometimes the signatures of the witnesses as well, depending on the document's requirements. Think of it as a 2+1 rule. Two witnesses plus the notary are needed to validate the mark properly. Question 3. A notary is asked to notarize a power of attorney for their spouse. The notary will not receive any financial benefit from the transaction. The notary should A. Proceed, as there is no financial interest. B. Refuse, as this is a prohibited conflict of interest. C. Proceed, but only if another family member is present. D. Proceed, but waive the notarial fee. Answer: B. Refuse, as this is a prohibited conflict of interest. A notary public is explicitly prohibited from notarizing for their own spouse or civil union partner. This rule is absolute and is designed to prevent conflicts of interest, whether real or perceived, and applies even if the notary has no direct financial stake in the transaction. The close personal relationship itself creates the conflict. A simple way to remember this is that a notary cannot act in any matter involving their spouse or civil union partner, period. Question 4. After a New Jersey notary receives their commission certificate from the state treasurer, they must take and subscribe an oath of office within A. 30 days. B. 45 days. C. 3 months. D. 1 year. Answer: C. 3 months. Receiving the commission certificate is not the final step to becoming a notary. The oath of office must be completed to finalize the process. New Jersey law mandates that this oath be taken at the county clerk's office in the notary's county of residence within 3 months of the commission's date. Failing to meet this deadline will result in the commission being voided, requiring the applicant to start the entire process over again. Always treat the 3-month oath deadline as a critical, non-negotiable final step. Question 5. What is the legal status of a notarial journal in New Jersey? A. It is legally mandatory for all notarial acts. B. It is legally mandatory only for real estate and loan documents. C. It is not required by law but is strongly recommended as a best practice. D. It is required and must be submitted to the state treasurer annually. Answer: C. It is not required by law but is strongly recommended as a best practice. While New Jersey law does not legally require notaries to maintain a journal of their acts, it is considered an essential tool for limiting liability and is strongly recommended by the state treasurer. A detailed journal serves as the notary's official record and can provide crucial evidence if a notarization is ever questioned or challenged in court. For example, if someone falsely claims their signature was forged, the journal entry with the date, time, ID details, and signer's signature can disprove the claim. The key takeaway is that although not mandatory, maintaining a journal is the hallmark of a professional and prudent notary. Question 6. A signer presents a document written entirely in Italian. The notary does not speak or read Italian, but the signer is fluent in both Italian and English and can communicate clearly with the notary. The notary should A. Refuse to notarize because the notary cannot read the document. B. Proceed with the notarization, ensuring the notarial certificate is in English. C. Require the signer to provide a certified English translation before proceeding. D. Find a certified translator to be present during the notarization. Answer: B. Proceed with the notarization, ensuring the notarial certificate is in English. A notary's primary function is to verify the identity of the signer and witness the signing of the document, not to validate the document's content. Therefore, a notary is not required to be able to read the document itself, as long as they can communicate directly with the signer in a shared language. The notary must be able to perform all parts of the notarial ceremony, such as administering an oath and filling out the notarial certificate, which must be in English. Just remember, your job is about the signer and the signature, not the foreign language text. Question 7. What is the maximum fee a New Jersey notary may charge for taking an acknowledgement? A. $15. B. $10. C. $5. D. $2.50. Answer: D. $2.50. New Jersey strictly regulates the maximum fees a notary can charge for most common notarial acts to ensure services remain accessible. For taking an acknowledgement or for administering an oath for a jurat, the maximum allowable fee is $2.50 per notarial act. Charging more than the statutorily set fee is a violation of notary law and can lead to penalties. Always keep a list of the state-mandated fees handy, as they are much lower than in many other states and are not open to negotiation. Question 8. A New Jersey Notary Public's commission is valid for a term of A. 4 years. B. 5 years. C. 7 years. D. 10 years. Answer: B. 5 years. The standard term of a notary public commission in the state of New Jersey is 5 years. This term begins on the date the commission is issued by the state treasurer and ends 5 years later, as indicated on the notary's commission certificate and official stamp. It is the notary's responsibility to track their expiration date and initiate the renewal process before the commission lapses to ensure they can continue to provide services without interruption. Remembering the 5-year term is a fundamental piece of knowledge for any New Jersey notary. Question 9. When performing a remote online notarization, RON, the notary must be physically located. A. In the same county as the signer. B. Anywhere in the United States, provided the technology platform is secure. C. Within the physical borders of the state of New Jersey. D. In a commercially zoned office building. Answer: C. Within the physical borders of the state of New Jersey. While the main benefit of remote online notarization, RON, is that the signer can be located anywhere in the world, the notary public must be physically present within the state of New Jersey at the time of the notarial act. The notary's physical location in their commissioning state establishes the legal jurisdiction for the act. For example, a notary on vacation in Florida cannot perform a RON for a signer in New York, even if the notary is commissioned in New Jersey. The rule is simple: for a New Jersey RON, the notary must be in New Jersey. Question 10. A notary who is not a licensed attorney advertises their services in a local newspaper. The advertisement must include a specific disclaimer, which states: A. Notary services do not constitute legal advice. B. I am not an attorney licensed to practice law in this state and I may not give legal advice or accept fees for legal advice. C. This notary is not responsible for the content of your documents. D. All fees are regulated by the New Jersey State Treasurer. Answer. B. I am not an attorney licensed to practice law in this state and I may not give legal advice or accept fees for legal advice. New Jersey law requires very specific language in advertisements by notaries who are not attorneys to prevent the unauthorized practice of law. This rule is especially important in communities where the term notarial publico might imply legal authority, as it does in many Latin American countries. The purpose of this exact wording is to clearly inform the public that the notary's role is limited and they cannot offer legal counsel or charge for it. This isn't just a suggestion, it's a mandatory, word-for-word disclaimer. Question 11. Under which of the following circumstances is a notary permitted, but not legally required, to refuse a notarization? A. The signer cannot provide satisfactory proof of identity. B. The document presented contains blank spaces. C. The notary is a direct party to the transaction. D. The notary reasonably believes the signer is being coerced or does not understand the document. Answer. D. The notary reasonably believes the signer is being coerced or does not understand the document. A notary has the discretion to refuse service if they have a good faith belief that the transaction is unlawful, improper, or that the signer lacks the capacity to sign or is being forced to do so. Unlike situations where identity cannot be proven or the document is incomplete, which require refusal, this scenario involves the notary's judgment to protect a potentially vulnerable individual. For instance, if an elderly person seems confused and pressured by a relative during the signing, the notary can and should refuse to proceed. This is a key part of the notary's role as an impartial witness, protecting the integrity of the transaction. Question 12. A signer presents a New Jersey driver's license that expired 2 years ago as proof of identity. The notary may A. Not accept the ID because it is expired. B. Accept the ID, provided it was issued within the last 5 years. C. Accept the ID only if the signer is personally known to the notary. D. Not accept the ID unless the signer also provides a valid birth certificate. Answer. B. Accept the ID, provided it was issued within the last 5 years. New Jersey has a specific and somewhat unusual rule regarding expired identification. A notary can accept an expired driver's license or non-driver ID card issued by the New Jersey Motor Vehicle Commission as satisfactory evidence of identity, but only if the ID was issued within the 5 years preceding the notarial act. This law recognizes that physical appearance doesn't drastically change in a few years, making the photo a reliable identifier even if the card is expired. Always check the issuance date, not just the expiration date, on an expired NJ license. Question 13. A New Jersey Notary Public has statewide jurisdiction, which means they can A. Notarize documents for New Jersey residents only. B. Perform notarial acts anywhere within the geographical borders of New Jersey. C. Perform notarial acts in New Jersey and any bordering states, New York, PA, DE. D. Notarize documents in any state, as long as the document will be filed in New Jersey. Answer. B. Perform notarial acts anywhere within the geographical borders of New Jersey. A notary's jurisdiction refers to the geographic area in which they are authorized to act. For a New Jersey notary, this area is the entire state, not just their county of residence. This means a notary who lives in Bergen County can travel to Cape May County and perform a valid notarization there. However, their authority stops at the state line. They cannot perform a traditional, in-person notarization in New York or Pennsylvania. The key is that the notary must be physically located within New Jersey when the act occurs. Question 14. A client presents a purchase contract with a blank line where the final sale price should be. The client states they will fill it in after the notarization. The notary's correct course of action is to A. Have the client draw a line through the blank space and initial it. B. Inform the client that the document cannot be notarized until the blank space is filled in. C. Note in the journal that the price was left blank at the signer's request. D. Fill in the space with the words, "to be determined," before notarizing. Answer. B. Inform the client that the document cannot be notarized until the blank space is filled in. A notary must never notarize a document that is incomplete or contains blank spaces where material information should be present. Doing so could facilitate fraud, as information could be added or altered after the fact. The notary must refuse the notarization and explain to the signer that all blanks must be filled in or lined through and initialed by the signer before the notarial act can be completed. This rule protects both the public and the notary by ensuring the document is in its final form at the time of signing. Question 15. The venue section of a notarial certificate, which typically reads, State of New Jersey, County of ___________________, establishes A. The county where the signer resides. B. The county where the document will be recorded. C. The state and county where the notarization took place. D. The notary's county of commission. Answer. C. The state and county where the notarization took place. The venue is a mandatory component of every notarial certificate, and its purpose is to record the precise location where the notarial act was performed. It specifies the state and county in which the signer personally appeared before the notary. For example, if a notary commissioned in Essex County performs a notarization while meeting a client in Monmouth County, the venue on the certificate must state Monmouth County. Think of the venue as the where of the notarization, which is critical for legal validity. Question 16. A notary changes their legal name after getting married. To continue notarizing, they must first A. Begin using the new name and order a new stamp immediately. B. Use up their old stamp and then re-register under the new name. C. Surrender their commission and completely reapply from scratch. D. Re-register under the new name with the state treasurer and take a new oath of office. Answer. D. Re-register under the new name with the state treasurer and take a new oath of office. A legal name change requires a formal update to a notary's commission. The notary must notify the state treasurer, complete a name change application, receive an amended commission certificate, and then take a new oath of office at the county clerk's office under the new name. Only after completing this entire process can they purchase a new stamp and notarize under their new name. Simply starting to use a new name and stamp without re-registering and taking a new oath is not compliant with state law. Question 17. A person asks a New Jersey notary to provide a certified copy of their birth certificate. The notary should A. Make a photocopy and attach a certificate stating it is a true and correct copy. B. Direct the person to the official government agency that issued the document. C. Make a copy and have the owner sign a statement about its authenticity, which the notary then notarizes. D. Refuse, as notaries cannot certify any type of document copy. Answer. B. Direct the person to the official government agency that issued the document. New Jersey notaries are not authorized to make certified copies of vital records like birth certificates, death certificates, or marriage certificates, nor can they certify publicly recordable documents like deeds. The authority to issue certified copies of these documents rests solely with the designated custodian of the records, such as the Office of Vital Statistics or the county clerk. While a notary can sometimes notarize a signer's statement about a copy, an act called copy certification by owner, this is not appropriate for a vital record. The proper action is to refuse and guide the person to the correct issuing agency. Question 18. A New Jersey notary who uses a seal embosser must know that the embosser A. Is a legally acceptable substitute for the required ink stamp. B. Is prohibited on documents that will be recorded, such as deeds. C. Does not, by itself, fulfill the legal requirement for a notarial seal. D. must contain the notary's commission ID number in addition to their name. Answer: C. Does not, by itself, fulfill the legal requirement for a notarial seal. The official seal required by New Jersey law is an ink stamp because its impression is photographically reproducible. A seal embosser, which creates a raised impression, can be used in addition to the ink stamp but never as a replacement for it. The embossed seal is often difficult to see on photocopies or scans, which is why the ink stamp is the mandatory tool. Think of the ink stamp as the primary, required seal and the embosser as an optional, secondary enhancement. Question 19. If a notary's commission expires, they must: A. Stop performing all notarial acts immediately. B. Continue notarizing for up to 30 days as long as a renewal application is pending. C. Perform notarizations but use the phrase, "commission expired," on the stamp. D. Backdate any notarizations to a date when the commission was valid. Answer: A. Stop performing all notarial acts immediately. A notary's authority to act is tied directly to their commission term. The moment the commission expires, that authority ceases completely. There is no grace period for renewal, and performing any notarial act with an expired commission is illegal. Any act performed after expiration is invalid, and engaging in such activity, including backdating documents, can lead to serious legal and financial penalties. A notary must wait until their renewal is fully processed and they have taken the new oath of office before resuming their duties. Question 20. A notary moves from one city in New Jersey to another. They are required to notify the state treasurer of their change of address within: A. 10 days. B. 30 days. C. 60 days. D. The time of commission renewal. Answer: A. 10 days. New Jersey law requires a notary to report any change in their business or residence address to the state treasurer within 10 days of the move. This is a strict administrative rule that ensures the state's records are always current, which is essential for communication and verification purposes. This timeline is often confused with the 30-day requirement for reporting a name change. A handy way to remember is, a quick move requires a quick update, 10 days. Question 21. For a jurat, the signer must state, in the notary's presence, that the A. Signature on the document is their own. B. Notary is not a party to the transaction. C. Statements in the document are true and correct. D. Document was executed without coercion. Answer: C. The statements in the document are true and correct. The core purpose of a jurat is for the signer to swear or affirm, under penalty of perjury, that the contents of the document are truthful. Unlike an acknowledgement where the signer simply confirms their signature is genuine, a jurat involves taking an oath or affirmation about the document's substance. The notary must administer this oath or affirmation verbally before completing the jurat certificate. A good memory aid is that a jurat involves swearing, connecting it to telling the truth about the document's contents. Question 22. Which of the following is not required by New Jersey law for a notary public? A. Be at least 18 years of age. B. Reside in New Jersey or have a place of employment in the state. C. Pass a state-administered examination. D. Obtain a surety bond in the amount of $15,000. Answer: D. Obtain a surety bond in the amount of $15,000. While many states require notaries to be bonded as a form of financial protection for the public, New Jersey does not mandate a surety bond. Applicants must meet age and residency/employment requirements and must pass an exam, but purchasing a bond is not part of the commissioning process. Although a bond is not required, many notaries choose to purchase errors and omissions, (E&O), insurance for their own protection. The key distinction to remember for the exam is that bonds are not a state requirement in NJ. Question 23. A notary is asked to identify a signer using one credible witness. To do so, the credible witness must: A. be personally known to the notary. B. Be a close family member of the signer. C. Sign the document that is being notarized. D. Present 2 forms of valid government-issued ID. Answer: A. Be personally known to the notary. When using a credible witness for identification, the witness serves as a human ID card, vouching for the signer's identity. For this to be a reliable method, the notary must have personal knowledge of the credible witness. The witness then takes an oath or affirmation from the notary and confirms the identity of the document signer. The witness does not need to know the signer personally, though they usually do, but must be able to swear to their identity under oath. The chain of trust flows from the notary to the witness, and then from the witness to the signer. Question 24. A notary is also a real estate agent and is handling a transaction in which they will earn a commission. The notary is asked to notarize the seller's signature on the deed. The notary should: A. Proceed with the notarization since it is part of their job. B. Refuse, as receiving a commission creates a disqualifying financial interest. C. Proceed, but waive the notarial fee to avoid a conflict. D. Proceed, but disclose their role as the agent in the notarial certificate. Answer: B. Refuse, as receiving a commission creates a disqualifying financial interest. A notary must be an impartial party to a transaction and cannot notarize a signature on a document if they have a direct financial or beneficial interest in it. Earning a real estate commission from the sale of the property constitutes a significant financial interest that disqualifies the notary from acting in that transaction. Waiving the small notarial fee does not eliminate the much larger conflict of interest created by the commission. To maintain impartiality, the notary must refuse and have another, disinterested notary perform the act. Question 25. An acknowledgement certificate's primary purpose is to verify that the signer: A. Read and understood the document. B. Swore that the contents of the document are true. C. Personally appeared before the notary and confirmed they willingly signed the document. D. Is the person named in the document as the beneficiary? Answer: C. Personally appeared before the notary and confirmed they willingly signed the document. The function of an acknowledgement is for a signer to appear before a notary and declare, or acknowledge, that they executed the document for the purposes stated within it. The notary verifies the signer's identity and that the acknowledgement was made willingly. Unlike a jurat, an acknowledgement does not involve the signer swearing to the truthfulness of the document's contents, only to the authenticity and voluntary nature of their signature. Remember, an acknowledgement is about confirming the act of signing, while a jurat is about confirming the truth of the content.